Well, hello, everybody. Thank you for tuning in. Welcome to another live stream webinar from Firearms Legal Protection. So I've done several of these. I've met some of you in person. Many of you I have not met in person. My name is Plenty Gale. I lead a lot of the marketing efforts here at FLP. And tonight we have a very interesting topic, and I see that people are tuning in from all over. We see people in South Carolina, North Carolina, California, Texas, Michigan, Arizona, all over. That's exciting. It's great when we see people all over the country. We're here in Dallas, and so we see a lot of people from our neck of the woods, but this stuff applies to everybody. So we're glad to see that from all over. So we have a very interesting topic tonight, and this is a topic that may have got some of you interested in this stuff to begin with. It's what happens after you protect yourself. You've prepared with your firearm or your knife or your pepper spray or whatever to defend yourself, but many of you know that often just starts the battle. It's not the end of it. Things don't end with the pull of a trigger. And so tonight we have attorney James Cook, who is going to tell us all about this topic. Again, many of you probably know something about it, but it's always great to have a refresher and really look at this stuff, what it means, why it's powerful, and why legal protection is so important. So James Cook is a criminal defense attorney practicing out of Colorado Springs, Colorado. He started his legal career with the district attorney's office for the 4th Judicial District of Colorado before leaving in 2013 and entering private practice. James now runs his own firm specializing in criminal defense. He also opened a gunsmithing shop and holds a federal firearm license. We were talking before this started about some of that gunsmithing stuff, about some of the NFA stuff. He's very experienced in a lot of that fun stuff. So James primarily practices in the area of criminal defense with a special emphasis on firearms cases, and also advises and consults on firearms compliance issues, purchasing National Firearms Act regulated items, silencers, FFL dealer compliance issues, and other legal matters related to owning, building, or selling firearms. So all that to say, we've got the right man for the job here. So welcome, James.
Thank you.
Glad to have you I'm in the discussion tonight. That is quite a CV of firearms experience.
Yeah, well, criminal defense and firearms, that's kind of what I do.
Awesome. Well, just kind of the run of the show tonight. So James is going to take it away with the presentation. If you have things related to a slide that's on screen at the moment, go ahead and ask it in the chat. Somebody's saying no audio. Oh, that just looks like it's on Rick's end. It looks like he got it resolved. Okay. So if you have a question related to a specific screen or bullet point on the screen, go ahead and list that. We have taken some questions in advance that we're going to ask and answer afterwards. If you have a question or something that's not related to a specific topic on the screen, hold it to the end and we'll do all those Q&As. We'll probably get to your question or one that's very similar. So with that, James, let's take it away.
Thank you, Plenty. So tonight we're going to be talking about is essentially what to do after the gun goes bang. If you have to use a firearm as self-defense, what do you need to do? What is law enforcement going to do? What are the courts going to do to you? So I want to set the scene first. In order to kind of walk through this, we need to have an idea of a situation in mind. So here's kind of the scene. It's the end of the day. I'm done teaching this class tonight. I walk out towards my truck that's sitting in the parking lot. And as I'm head out towards my truck, I'm walking towards the rear end, going around the tailgate, and all of a sudden, after I turn, there is a guy standing in front of the hood of my truck, and he walks around to the side. We are 5 yards apart from each other, and this guy is just looking crazy. He's got on a psycho clown mask. He's holding a knife in his hand, and he's screaming, "I'm going to kill the next person I see," and he and I just locked eyes. And at this point, I think the only reasonable option I have is I draw my pistol, I point at his chest, I pull the trigger 3 times, and he drops to the ground dead. So what exactly are the legal rules that we need to kind of get as a ground rule on this? Well, first, understand that self-defense is going to be the standard there. It's going to be the laws that we're going to be talking about here. And the general standard for self-defense is I have to believe that myself or somebody else is in imminent danger of death or serious bodily injury. And the second part of this is I have to believe that I don't have another more reasonable option to solve this than using deadly force. And when we talk about different scenarios, should I pull the trigger? Am I going to be justified? All that kind of stuff. Understand when we're talking about this, those are the points that I'm trying to prove when I get to court. That I believed I was in imminent danger of death or serious bodily injury, and that I didn't have a better option than to use deadly force. And just because I think that I can argue those 2 points, I think that I'm in imminent danger, I don't think I have a better option. Just because I can argue that doesn't mean that the DA isn't going to charge me, doesn't mean that I'm not going to have to go to trial, I'm not going to have to prove myself in court, that ultimately I'm not going to have 12 people who are too dumb to get out of jury duty that day decide whether or not I am guilty and what's going to happen to me for the rest of my life. So that being said, let's talk about that scenario there. I've used the gun in self-defense. And one other really quick thing that I want to point out here, the reason that you are using a gun, the reason you are using deadly force is because the consequences of not using deadly force are worse than the consequences of using deadly force. When we talk about shooting somebody in self-defense, this is not going to be a fun thing. It's not like the police are going to show up at the scene, they're going to pat you on the back, and they're going to say, thank you for saving us the work of taking this guy off the street. They're going to treat you like a criminal. They're going to investigate that case because from law enforcement's perspective, there is a dead body on the ground, and we have to investigate, and we have to find out exactly what happened. It's not going to be pretty. It's not going to be fun. People are not going to treat you like the hero of the day, unfortunately, but you are saving your life. You're saving somebody else's life. So what should you do? If I'm in that situation, I shot the psycho clown slasher next to my pickup truck in the parking lot. What should I do? First, you got to make sure the scene is safe. Understand the reason that I'm using deadly force because I think I'm about to be killed. I think my wife or my kids or somebody else is about to be killed. So I need to make sure that the scene is safe. Just because I shot one guy next to my truck, just because I shot some guy in my living room that broke into my house, doesn't mean that he doesn't have an accomplice. Rats travel in packs. And if there is one guy that I am shooting here, he may have a friend that's watching it, the friend that's aiding him, friend that's helping him, and I need to make sure that I'm safe. Now, that doesn't necessarily mean hop in my truck and drive home and then call the police, something like that, but get to a safe place. Walk back into my office, get into my truck and lock the doors and make sure there's nobody else around. If I can see the scene really well and I can see, hey, there's nobody else here, that's okay. Stay there, get help coming to the scene. But first and foremost, make sure the people you're with are safe. And the second thing is you need to get help rolling to the scene. Now, a lot of people think, well, the second thing you should do is you got to provide, medical aid to somebody that you've shot. And I think that's a really bad idea. You have no legal requirement that you have to provide medical attention to somebody that you just shot. And in fact, if you are so afraid of this person that you believe that you're in imminent danger of death or serious bodily injury, going and getting within their wingspan is a very bad idea. If I'm carrying a gun, there's about a 90% chance I've also got a knife on me too. And if this guy that I just shot had a gun and I decide I'm going to go over there and give him medical aid, in my mind, there's a 90% chance he's got a knife in his pocket too. And I don't want to get within his wingspan where he can cause that kind of harm to me. And if you watch law enforcement videos, when they use deadly force on somebody, the body cam videos, you're going to see the law enforcement is going to go over there. They're going to give medical aid to that person. But the first thing they're always going to do, they're going to handcuff that person. And law enforcement gets a lot of heat for doing that. But the reason they do that is so that if that person does reach into their pocket and pull something out, or they happen to be strong enough, they can reach up, they can grab that officer, they can cause some kind of harm, that they're not going to be able to do that. And I know that if I, wind up shooting some burglar in my house at 2 a.m. in the middle of the night, and it's some crackhead, meth addict that is hopped up on something really bad, I don't think that the purple fuzzy handcuffs that my wife has in her dresser drawer are going to be enough to restrain that guy to keep him from causing me any kind of harm if I go over and give him first aid. So I'm not going to do that. I'm going to call help and get help rolling to the scene to help out for what I need. So call 911. If there's somebody else at the scene that can call, if there's a witness that sees me shoot this guy, if there's somebody that hears those gunshots and comes over and says, hey, what's going on here? If I can point to that person and say, hey, call 911 for me. This guy's just been shot. I just shot this guy. That's okay to do. What if you have to call 911 yourself, though? Because there's not always going to be a witness, especially if I shoot somebody in my own home. Don't think that your neighbors are going to hear this and they're going to call the cops for you. You'd be surprised how many people negligently discharge firearms in their home, and nobody finds out about it 2 days later until they find a bullet in the toaster 2 blocks down the street. I had that case. It was an AK-74. Don't think that somebody's going to call the police for you. If there's no one around, you have to call the police yourself. So what do 911 calls look like? Well, understand first and foremost, 911 calls are all tape recorded. And 911 has 2 jobs. The first job of 911 dispatchers, is to send help to where it is needed. So to that end, you need to give them the information that they need to send the people they need and the speed they need to send them. So what I would say is, 911, they're going to say, 911, what's the location of your emergency? Give them the location. Tell them where you are. They're probably going to ask you what your name is. Give them your name. That's completely fine. Then they're going to ask you the loaded question. And the loaded question is this. It's going to be some variation of what is the nature of your emergency? And that's the loaded question, because what they need to know is how fast to send people and who to send. So what I would say is somebody's been shot. We need police. We need paramedics. Please hurry. Click. Hang up the phone. Because the secondary job of 911 is to conduct an unmirandized interrogation of anybody that is on the line. And we have all heard 911 calls where somebody has stayed on the line too long. The case down in Florida involving Trayvon Martin years ago, where media agencies were cutting the phone call to make it sound like the person that did it was worse than they were. There was a case in Texas years ago where a guy was on the phone with 911 and said, "Hey, there's these guys breaking into my neighbor's house. I'm going to go over there and stop them." And the dispatcher said, "No, don't go over there." And he went and did and shot the guys. And they used that as evidence to say, well, he's disregarding 911 dispatchers. Don't stay on the phone. First and foremost, you're not going to be paying attention to your scene. You're going to be listening to the 911 call. You're going to be talking to the dispatcher. You're not paying attention to things. The second, you can say things that can wind up hurting your case. I want you to get off that phone. And I've seen the question pop up a couple of times here, and it was asked previously, should I call for 2 ambulances? Well, they're going to send as many as they can, especially if you say somebody's been shot. They're not just going to send 1 ambulance slowly. There's going to be multiple people there. And the question is, do I need to say that I should be taken away to a hospital? Honestly, I don't want you being so focused on I need to get an ambulance for myself. If you get an ambulance for yourself, that's great. That's fine. What you need to be focused on is asking for an attorney. We're going to talk about that in a little bit here. But when you're on the phone, 911, get off the phone after you've given them the information. Somebody's been shot. We need police. We need paramedics. Please hurry. Tell them to get there quickly. And the question always comes up, should I say I've shot somebody or somebody's been shot? And I'll give you my answer to that. It really isn't going to matter too much if you say I shot somebody. Because if you shot someone in self-defense, it's going to come out that it was you. You're not going to be going in there after you shot somebody in self-defense and then getting into an interview room and saying, hey, I think it was some guy 2 blocks away. I'm the one that shot him, but I'm going to blame it on the one-armed man down the block here. Because if you shot somebody in self-defense, you're going to be admitting, yes, I did it. Here's why I did it. Here was my reasons for doing it. And here's why I had to do it. So what saying somebody's been shot buys you is if you stay on the phone a little bit too long and you answer the next question. So if I say somebody's been shot, what is the natural follow-up question for somebody to ask? Who? If you say I shot somebody, what is the natural follow-up question to ask? Why? That's the question I don't want you answering under any circumstances without talking to me. Why you did it. If they ask who and you say it was some guy in a parking lot with a knife and a psycho clown mask, okay, we haven't really heard our case there. But if they ask why you shot somebody and you start going into that really quickly, in the moments after you've just pulled the trigger in the most intense situation you'll ever be in your life, that's where you can say something that you can really wind up hurting yourself with. So get off the phone, 911. And understand, they're going to blow your phone up. You are going to be getting calls back from 911, from unknown numbers, from local numbers, all sorts of stuff. They're going to try to get you to answer that phone call. You don't need to be on the phone with them. Another thing that I've heard people say is, well, I need to stay on the phone so that I can give them a description of what I'm wearing. I need to say that I acted in self-defense, all those sort of things. Understand law enforcement is going to treat you exactly the same. If you shot somebody in your own home and you say, I'm the homeowner, I live here, when they arrive at the scene, they're not going to know that you live there. And as far as they know, you just murdered somebody. There's a cold body on the floor and a warm gun in your hand. They're going to treat you the same whether you live there or you're just some guy that happened into the house from the block. It's not going to make any kind of difference in your case. So once you have got help coming to the scene, you need to be aware of how law enforcement is going to react when you get there. And you should not have a gun in your hand when the cops arrive. And a lot of people think, well, I'm going to hold some guy at gunpoint until the cops get here. And I think that's a really, really bad idea, especially if somebody's broken into your home. Get them out of the house. All right. All that time that you have got this person at gunpoint, people think that real life is going to be like 24. You know, it's Jack Bauer. I'm going to point my gun at him. And because I got the drop on him, I pointed my gun at him first. He's going to drop his gun. And then he's going to spend the next 5 minutes telling me all his evil terrorist plans. That's not how real life actually works. I've seen enough of these cases where people thought they could point a gun at somebody and that they're immediately going to surrender, and found out the hard way that that is not true. That I can tell you that is absolutely not true. If you point a gun at somebody, you're going to engage that person's fight or flight reflex. They're either going to decide, oh crap, I'm about to get shot. I need to get out of here as quickly as possible. Or they're going to decide, oh crap, I'm about to get shot. I need to fight for my life. And if that person decides to fight for their life and you've been holding them at gunpoint, if they're on the ground in the kneeling position with their hands above their head, and all of a sudden you see that, hey, they're getting up and they're about to charge me, and you wind up shooting them in the head, that's going to look like you just executed somebody on the ground. And that's going to be a really hard thing that I'm going to have to explain to a jury why it looks like you just executed somebody. So don't do it. Get them out of the house. At that point that you're holding that person at gunpoint, chances are, especially if we're talking about a residential burglary, this is not that guy's first rodeo. And at least here in Colorado, we've got habitual criminal sentencing. If you've been convicted of 2 prior major felonies and you're about to get convicted of your third, now we're talking about having to do 4 times the maximum of the possible sentence there, and that's mandatory time that you have to serve. So we're looking at, for a residential burglary, 24 years mandatory DOC. So the only thing standing between that person and the next 24 years in prison is you holding that gun. It is a much better idea to get them out, get them away from the scene. Don't hold somebody at gunpoint. I can tell you other stories about that, but we're going to move on from that point. So when cops arrive, they are going to be looking for, first and foremost, officer safety. That is the number one thing cops care about. And if you've got a gun in your hand, you are a threat to those officers. Another reason why you don't want to have somebody held at gunpoint, because you've got a gun in your hand. And as they arrive there at the scene, it looks like, hey, this guy might be about to kill somebody. And that officer may be thinking, I've got to shoot you to save that person who may be the homeowner. And they don't know the difference. And this can end very tragically. So get them out of the house. Don't have the gun in your hand. Best place to have your gun. If you've got a handgun, if you're a concealed carry, you've got a holster, reholster it. Because you can keep your hands up, you can keep your hand off the gun, but it's still close by. You can reach it if necessary. It's not going to fall into somebody else's hands. My 8-year-old daughter is not going to walk into the room and pick up the gun. The buddy of the guy that I just shot is not going to go over there, grab the gun, and then use it against me. I'm still maintaining control. If you got a rifle or a shotgun, sling it across your front, sling it across your back, have it close by so you can keep your hands off of it. But if you need it, it's still close. You're still in control of it. If you don't have a sling or a holster, set it down on a table, take a couple of steps away. Make sure that you're maintaining visual control over it. You're not letting it fall into somebody else's hands. You can get to it quickly, but don't have that gun in your hand. We had a case that happened up in Aurora, Colorado about 2 years ago. And there was an elderly Vietnam veteran who, kind of like my dad, is a little bit deaf from years of shooting and that sort of stuff. He didn't have his hearing aids in. And he had his grandchild over spending the night with him. And there was a crazy guy that was running up and down the street trying all the locks on the doors. Police were already called. They were already on the way because this guy tried to get into a couple of houses. And ultimately, he walks up to this elderly vet's house. He opens up the front door, and turns out it was unlocked. He runs inside. He sees the elderly vet's grandson. He picks him up, brings him back to the bathroom, and starts taking off his clothes. And by all accounts, this crazy guy was going to rape his grandson. Now, granddad was not going to have that happen, so he goes into his bedroom, reaches into his closet, pulls out a shotgun, walks into the bathroom, and blows the guy away. Hero of the day. Unfortunately, Aurora PD heard the gunshot inside. They run up, they see the open front door, they run inside, they see this granddad holding a shotgun, they yell, "Aurora PD, drop the gun!" He doesn't hear what they're saying. He turns around with the shotgun in his hands, held up port arms, and they shot him 6 times. That guy was an absolute hero for what he did, but he wound up getting shot because he had the gun in his hand when police showed up. So don't be that guy. All right. Now, when law enforcement shows up, they are going to cuff you. They are going to be detained. They are going to treat everybody as a bad guy until they know something different. They're going to investigate the scene. They're going to try to interrogate you. And what you want to do at that time is you have got to lawyer up. And what I mean by lawyer up is you have got to actually ask for an attorney. I know that a lot of people are going to think, well, I've got a Fifth Amendment right against self-incrimination, so I can just be quiet and not say anything to them. That's true. You absolutely can. But understand the way the Supreme Court has ruled on this is that if you invoke your right to remain silent, law enforcement has to wait a reasonable amount of time before they can try to interrogate you again. What's a reasonable amount of time? Almost whatever an officer thinks that he can sell to a judge in court. And that could be, if you are an absolute crying, blood-burning mess at the scene, okay, that may be 45 minutes or an hour until you've calmed down, and maybe even longer if it takes even longer to calm down. Or if you're a very cool, collected customer, it may be 5 minutes. Where we talked about earlier about, well, should you get an ambulance to take you away from the scene? Yeah, if you're just going to say, I'm not going to make any kind of statement, yeah, get an ambulance to take you away from the scene to try to separate you from law enforcement. But I think where a lot of people get confused is they think that if I ask for an ambulance, then they're just going to put me in an ambulance and send me to the hospital, and they're going to give me a call 2 days later and say, hey, we'd like to talk about what happened. That's not the case. You're going to be riding there with a police officer. That officer is going to be talking to you. He's going to be pretending to be your friend. He's going to be asking you about what happened. He's going to be trying to interrogate you. Just because you're in an ambulance doesn't mean they don't get to try to question you anymore. And when you get to the hospital, when they're examining you, there's going to be an officer there watching you. You're going to be handcuffed while they're doing this. They're maybe going to take you into a room. They're going to set you down in a bed and give you some anti-anxiety medication, and you're going to be handcuffed to a bed, and there's going to be an officer watching you the whole time. Just because you ask for an ambulance does not mean the officers go away. What you need to do is ask for a lawyer. Because conversely, the Supreme Court has said if you ask for your lawyer, they have to try to get you in touch with your attorney. It doesn't mean necessarily you're going to get in touch with your attorney, because if you don't have a plan who your lawyer is, and you simply say, I want to talk to a lawyer, and they say, great, who's your lawyer? And you say, I don't know, give me a copy of the phone book. I guarantee you go to any police station, you pull out the phone book they've got in there for defendants, for people being interrogated. The first thing that people do whenever a new phone book shows up is they pull out all the pages for the lawyers. They can hold on to it to remember who their lawyer is. They're all going to be gone by the time you get in there. And quite frankly, most of us younger attorneys don't even bother advertising in the yellow pages anymore. And that's what they're going to give you if you don't know who your lawyer is. So again, I'm obviously skipping ahead a little bit here, but that's why having something like FLP, where you can get a hold of an attorney, you know that you have an attorney that can represent you, is absolutely so vital at that point. But understand they are there to do a job. And what law enforcement's job is to investigate a crime. And when they see a dead body on the floor, they're not necessarily thinking self-defense. Did James Cook act in self-defense, or did he just murder somebody? I'm going to give you a very simple version of the Colorado statute for murder. A murder is the intentional killing of a human being. In that scenario that we started out talking about here, I shot the guy in the Psycho Clown mask with a knife next to my truck. Did I intentionally kill that guy? Yeah, I did. I pointed a gun at his chest. I pulled the trigger 3 times. I committed an action which was likely to and did cause that person to lose their life. I have just committed a murder. Now, self-defense is a completely separate statute. Self-defense, the question of did I act in self-defense, is a question ultimately for the district attorney's office when they're deciding if they're going to file charges against me, or if it goes that far, for the jury that is now deciding my fate. Law enforcement simply writes up their report and they hand that over to the DA's office. So as far as they're concerned, when they see that, yeah, here's a dead body on the floor and James Cook has got the warm gun in his hand and he's the one who did it, their question is, not necessarily going to be, did he act in self-defense? Because that's for the DA's office to decide. They're going to investigate it to the fullest. And I know a lot of people think, well, why are they going to investigate this so much? If I shot some guy in my home that's obviously threatening me, why are they going to detain me, take me down to the station, put me in cuffs, do all that kind of stuff? And a real world example. About 10 years ago in Falcon, Colorado, out here in El Paso County, there was a woman that calls up 911 and says, my ex-husband is breaking into my house and he is trying to kill me and I shot him and killed him. So the El Paso County Sheriff's Office shows up there at the scene, and sure enough, they get there. They find a dead body on the ground standing in front of this woman's trailer door. They find a shotgun blast through the front door, and they run his history. She's got a domestic violence protection order against him. He smells like alcohol. They look at this scene and they say, yep, this looks like she was afraid for her life. She was defending herself. She shot him. Case closed. Detectives show up at the scene. The detectives notice he doesn't have a cell phone on him, which seems a little bit weird because everybody has a cell phone on them. So the detectives do their due diligence. They get a hold of the guy's cell phone company. They pull all the cell phone records. And what do they find in his text messages? They find that his ex-wife, they were in the process of getting divorced at the time, they were legally separated, has sent him a text message saying, hey, baby, I miss you. I need some good love. And can you come over tonight and let's have a good time? So he got drunk, got on his motorcycle, drove over to his ex-wife's house thinking he's going to get lucky, and got shot through the front door because her new boyfriend was really jealous of the separation present that he just bought himself, a brand new Harley Davidson. And because they were still legally married, just in the process of separating, they believed that if she killed him, if he had died, she would inherit all of his property, and then the new boyfriend would get the motorcycle. And after figuring out that she had called them over, they interrogated the boyfriend. The boyfriend admits the plot, and both of them wind up getting convicted of murder. And if the sheriff's department had just shown up there and said, hey, this looks like a good shoot, we're not going to investigate any further, they wouldn't have caught a couple of murderers. So that's why every time you have something, even when it looks really clear cut, there's always going to be an investigation. It's always going to be done in depth, and they're going to try to figure out what actually happened in this case. And that is exactly what is going to happen to you. Whether I shoot somebody in the parking lot or whether I shoot somebody in my home and I've got the even better make my day standard, they are going to investigate it to the fullest. So you need to lawyer up. You need to not say anything to them. And this is going to be the hardest thing you're ever going to do in your life because it's not normal for people to shoot somebody. Most of us have never shot somebody in self-defense. Even most people in the military or law enforcement never wind up shooting somebody. And if you happen to be somebody that does have to do that, because it is so unnatural, you are going to want to scream it from the mountaintops that you are 100% justified in everything that you did. You're going to want to explain to everybody that you talk to that, hey, I'm not a bad guy. I'm not a murderer. I was protecting myself. I was protecting my family. I was doing the right thing. But the problem is, in the moments after you have just used a gun in self-defense, you have done that most unthinkable thing where your adrenaline is going to be up, you're not going to be thinking clearly. If you start all of a sudden trying to explain what happened without having somebody to sit down and go over it with, you're not going to be able to describe it very well. The best example I can come up with this is if anybody's ever been in a car accident. I remember the last time I was in one, I was in Boulder, Colorado. This was about 15 years ago. I had this awesome F-150, and all of a sudden traffic stops really, really quickly, and I slam on my brakes, and I lightly bumper tap the car in front of me. And unfortunately, the woman in a Subaru Outback doing 45 behind me was looking at her cell phone and smashed into the back of my truck and nailed me, wound up totaling my truck. After I got out of my truck, 5 seconds after getting into that car accident, if you had asked me to describe exactly what happened, I wouldn't have been able to do it very well. My heart was fluttering. My adrenaline was really up. My face was flushed. I was, just super angry that somebody had just wrecked my truck. I was not able to describe it calm, collected, and explain exactly what happened. A couple of days later, after thinking about it, talking to people about it, describing what happened, going over it in my head a bunch of times, I could tell you exactly what happened. I could do it very clearly and concisely and cover everything that I needed to. And that's honestly what my job is as your attorney, is not to help you change your story around to make you look better, to manipulate the facts so that you sound like a better person than you actually were, is to help you get your story out, to explain what happened, get everything that we need to in one fell swoop there. Because if we have to go back later and change the story around, add on details, reopen the line of questioning there, it's not going to go as well because you're not going to get the story straight through multiple tellings of it. So we need to do it one time that covers absolutely everything it needs to, so that whoever it is in the DA's office that shows up on a Monday morning, I've had this happen to me where I show up and I think, hey, I've got a really light work week. I'm going to get caught up on everything. I'm going to be able to take off early on Friday. And then my boss walked in and slapped down a banker's box and said, hey, James, here is a banker's box full of police reports. Read this over and decide if we should charge this guy with something. That sucks. But I want that guy making that decision to have everything they need in that box to look at that from your statements and say, yep, he was justified. He believed he was in imminent danger. He believed he had no other option, and he reacted appropriately to it. And that's what my job as your attorney is. So what is going to happen with the legal system? After you have been interrogated by the police, after you've been taken out of the station, what is going to happen? Well, most states are going to have a 72-hour window where you have to be charged or released. Here in Colorado, law enforcement can hold you up to 72 hours without filing charges. So they can take me down to the main police station. They can hold me there in a holding cell for 72 hours. And at that 72-hour point, they've either got to say, okay, we're filing charges. We're going to book you into general population down at the Criminal Justice Center. Or they've got to release me and say, all right, we're going to keep an eye on you. And if we decide we're going to file charges, we're going to get a warrant. We're going to come and arrest you. Oftentimes what will happen, especially if the case is kind of questionable, is they will file charges. They'll just go ahead and file it because the district attorney's office can just dismiss them later if they think that they've made a mistake. And if they don't want you leaving, if they don't want you being able to get out there and tamper with witnesses or evidence or something like that, they're not going to let you out. They're going to hold you. So if they decide not to hold you, if they look at this and they say, you know what, we think this is probably a good shoot, but we don't have a final determination from the DA's office, they can release you. Understand your house is going to be a crime scene. If you shot somebody in your own home, that house is going to be a crime scene. There's going to be CSI tape all over it. You're not going to be allowed back in there for at least 3 days while they go and do the cool CSI stuff. Most of that stuff you see on TV is complete BS, but they can do stuff with, the lasers and figuring out trajectory and blood spatter and all that kind of stuff. They're going to go in and do it, and you're not going to be allowed in there. Your firearms are going to be taken. A lot of people get really, really worked up about this, and I understand why. Is if I shoot some guy and I do it in my house and I use my Glock 17, why are they going to take every gun in my home? I had a case years ago involving an individual that wound up negligently discharging an AR-15 in his living room. He was drinking and watching the movie Black Hawk Down, and he was cleaning his AR-15. So he was doing it like they taught him in the Army. Takes the whole thing apart, scrubs it down, he puts it back together, he puts a magazine back in the gun that he thinks is unloaded. He pulls the bolt back, lets it go. The bolt winds up closing. Those of you that are familiar with rifles right now are going, wait a second, if that magazine was empty, the bolt wouldn't have been able to close. Yes, you're correct. Because then when he pulled the trigger, he wound up putting a round through his ceiling. And when the sheriff's department shows up, they take every gun that he's got in his house. And the reason they gave was because we can't be sure exactly what gun he did it with. Even though when he got there, he told the police, this is the gun I did it with. Here's a warm .223 casing on the floor. There's a .22 caliber hole in my ceiling. They wind up taking his .45 pistol. They wind up taking his 12-gauge shotgun, his .22 rifle, every gun that he had in the house until it could be proven exactly which gun was used. And they're going to use that same argument against you if you shoot that burglar inside your home. They're going to say that, yep, it looks like he was shot 3 times. You got a Glock 17 in your hand there, but maybe you use that, fully auto, illegal Glock with the auto sear that you've got in your safe. So we've got to go and take every gun until we rule it out. Okay, that was a little side note there. So back to the legal process. Eventually, if I wind up getting charged on this, I'm going to be entitled to have a preliminary hearing. Preliminary hearing is when law enforcement has to come in, the DA's office has to compel it, and show that there is enough evidence to hold me on the case. And the standard for that is always tipped way in the balance of the district attorney's office. Here in Colorado, the standard is the DA has to prove that there's enough evidence to show that the officers had probable cause to arrest you. It's more likely than not that you committed some kind of a crime. And the the judge that decides that has to take every inference in the light most favorable to the people. So if they say, yep, we think that he did it, we think that the sky is green on this particular day, and that proves that he did it, the judge actually has to believe that if the sky was actually green at the time this happened, then that would prove that he did this here. You almost always lose preliminary hearings. So they're going to be able to hold you there. And then you're going to be set for trial. In different jurisdictions, the amount of time for speed trial varies. In Colorado, is 6 months. In most jurisdictions, it's going to be about 6 months. But understand, especially when we talk about murder cases, if they're doing DNA, if they're doing firearm ballistic analysis, if they're doing fingerprints, all those things, those take time, a lot of time, especially in the case of DNA, and you're probably not going to go to trial within 6 months. The prosecution can ask for more time. Your attorney is going to ask for more time because I don't want to go to trial half-cocked here. I want to make sure that I have all the evidence, because if something comes out a day before we go to trial there and I didn't object and say, hey, judge, we're still waiting for these results, and I need more time to get my information together so that I can rebut it, I need to make sure that I actually did that instead of going into trial without being prepared. So it's going to take you a while. And when you get to trial, the prosecution is always going to have the burden of proving your guilt beyond a reasonable doubt. It is never your burden to prove your innocence. It's always their burden to prove your guilt. Now, that doesn't necessarily work out in practical terms, because especially if they're accusing you of doing something bad, something that a juror is going to look and go, oh my God, he killed somebody. He's got to explain why he did that. The law says, and what the judge is going to explain to the jurors, is that you can't use my client's silence against him. You can't hold that against him as an admission of guilt because he didn't get up there and testify on his own behalf. I will tell you in practical terms, though, especially if we're talking about self-defense, you are going to have to testify. You're going to have to get up there. You're going to have to explain why you made the decision you made. And you're going to need to be able to explain it competently in front of a jury. And you're going to need to have somebody, especially if we're talking about a self-defense shooting, that's familiar with ballistics, that's familiar with how guns work. You would be shocked how off law enforcement can be. I had a murder case years ago involving a client who was caught with a .380 ACP pistol on him. The victim in the case was shot with a 9mm, one of the rounds that shot him. And it was a 9mm parabellum, 124 grain bullet. My client had a .380 loaded up with 90 grain bullets. And the law enforcement officer from the state ballistic lab got up there and said, yep, he was caught with the same caliber. And I said, wait a second, my client had a .380 and this guy was shot with a 124 grain 9mm. Is there anybody that loads 124 grain .380? Well, no, they don't. Okay, so my client didn't have the same caliber gun as the one that was used to shoot this guy. Well, yes. And if you had some public defender or somebody else that maybe is a good lawyer but doesn't know anything about firearms, they're going to let that slide by. And they're going to go, crap, he's got the same caliber of gun just because the bullet's the right diameter, but the wrong bullet in there. So you need to have somebody that's familiar with this kind of stuff defending you. And ultimately, as I said, you're going to have to get up there, just like, I think probably the self-defense case that we're all most familiar with, that we can all relate to, is going to be the Kyle Rittenhouse trial. And I think that Kyle Rittenhouse won that because he was able to get up there on the stand, explain why he made the decisions that he made, why he believed he was in danger, why he believed he didn't have another option. The prosecution got up there and badgered him. It looked like a bunch of jerks that are picking on a kid in front of a jury, and that absolutely worked out in his favor. And that is a calculated risk. He didn't have to get up there. I know that a lot of people in the national media were saying, oh, you shouldn't do that. Well, they were wrong. I absolutely would have done the exact same thing. And I think they were absolutely proven right by doing that. Ultimately, if the district attorney's office decides they're going to file charges against you, you have got to ride that train all the way to the end. You have got to be able to get up there in front of that jury, explain why you're not guilty, and then ultimately have it decided that way for being in front of a jury. So I will tell you before we get to the final questions here, the best thing, I'll make my pitch for FLP here. The best thing that having a program like FLP does is not the fact that, they will pay for your attorney's fees. If you have to go to trial, they'll pay me hundreds of thousands of dollars for all the hours I'm going to have to spend doing it. That's absolutely fantastic. That's wonderful. But the time when you really need to have an attorney, the most critical time in this case is going to be right after law enforcement shows up there. When you are being interrogated, you're being questioned by them. And if you don't know who your attorney is, you don't know how to get a hold of somebody, if you guys were here in one of my classes, I'd be happy to give you my business card. And I'll let you know that my business card has my personal cell phone number on it. And if you call my personal cell phone number at 2:30 in the morning, I'm not going to answer that phone call. So I've got too many clients that have drunk dialed me in the middle of the night and abused that privilege. And I've got the do not disturb feature on my iPhone. And the only numbers that get through to me at 2:30 in the morning on a Saturday are my wife, my parents, and the FLP emergency hotline. And I know that every other attorney that's in this town is going to be the same way. They don't answer random calls at 2:30 in the morning. Even if you get through to us, how do I know you're going to pay? How do I know you're good for it? All those sort of things. If you've got something like FLP, we can actually get out there. I can actually get out there and help you, and you can get through an attorney when you need it the most.
Awesome. Well, thank you so much, James. I appreciate you going through this, setting the stage, going through the context. So many of us know all this to be true, but we need a refresher on what exactly happens. And we've got a lot of people watching this who are FLP members. We had a question come up, I think, from two different people. If I'm an FLP member, who do I say is my attorney? Well, the point of that is you don't have any duty to tell the cops who your attorney is. The point is know who to call. So if you're an FLP member, you pull out this bad boy, or maybe you got one of the classic vintagey looking ones. You pull out this, there's a number on the back, and we're going to send that attorney right out to you. And if you're in Colorado Springs, it may be James. If you're in Dallas, Texas, it may be somebody else. We're going to dispatch that attorney. So when you say, I need to talk to an attorney right now, you don't have to think about it. You don't have to worry about it. We're going to get that figured out for you. So if you do not have an FLP membership, this is a great time to get one because we've got a special offer in the link before. This video after the stream is going to stay live. So if you have family, friends, loved ones, anybody who just got their carry permit and needs legal protection, you can just share that link with them. And it offers a great deal on firearms legal protection on all of our different plans. I saw somebody just post they moved from Washington State to Florida, and they need to get an insurance plan. That's great. We have this in Florida. So just going to go over our plans really quick. Maybe some of you signed up, but you don't remember exactly what came with your plan. Which plan did you sign up for? I'm just going to go through these real quick as a quick refresher to just look at our 3 different plans. If you're not signed up, again, a great opportunity. So check these out.
Firearms Legal Protection offers several different types of memberships, starting with memberships for individuals and memberships for families. Some of the plans, benefits, and prices vary state by state. For the purpose of this discussion, we're going to look at our most common plan that's available in most states. The individual basic membership plan is the bread and butter of our service. This plan includes protection in your state of residence, so not nationwide, just in your state. It also includes uncapped payment of attorney's fees for the defense of criminal cases and civil cases. Again, there is no maximum cap on what FLP will pay on these cases. This protection extends to all legal weapons. With the individual basic plan, you also have defense against extreme risk protection orders, otherwise known as red flag laws. FLP will fight those on your behalf. All plans, including the individual basic plan, have access to the 24/7 attorney-answered emergency hotline and access to the My FLP mobile app. Our newest benefit, expungement of criminal record on non-conviction incidents, is included with all plans, including the individual basic plan. Members of all plans can also enjoy access to digital content and special discounts. The next step up is the individual premium plan. This plan is ideal for members who travel across the country because this plan includes protection in all 50 states. This plan is also perfect for somebody who just wants the very best benefits. This plan includes all the benefits that I mentioned in individual basic, as well as several more. The individual premium plan includes payment of bail bond premium, generally up to $250,000 in most states. This plan also includes payment of expert witness fees, payment of investigator fees should either be needed in your case, coordination of counseling support, payment of lost wages if you're out of work during a trial, incident scene cleanup. Should you ever have an incident, you're going to need somebody to clean up that mess. That's covered in this plan. The individual premium plan also includes payment for incident-related firearm confiscation. So if your firearm is confiscated, FLP will write you a check for the value of that firearm. Many FLP members want the same protection that they receive for themselves to also apply to their family. That's why we have the family premium plan. For just a little bit more, you get protection, again, in all 50 states, all of the benefits that are included with the individual basic and individual premium plans, and you have this same protection that now applies to your spouse, and these benefits apply to all minor children. And we define minor children as any child living with you age 17 and younger. Whether you want the most affordable plan that covers all of the basic benefits, whether you want something a little bit more that has some premium benefits, or whether you want complete protection for your entire family, there are several plans available, and Firearms Legal Protection has a plan for you. If you are not already protected by Firearms Legal Protection, please check the description below this video where we have a special discount for viewers of this webinar. If you have friends or family who also need protection, feel free to share this code. We want everybody to enjoy the benefits and protection of Firearms Legal Protection membership plans.
All right. So if you don't have it yet, sign up at that link below. We got a great deal. Share it with friends and family. But in the meantime, James, are you ready to do some questions?
Yeah, let's do it.
Awesome. Well, I always appreciate our members send great questions, and a lot of them are sometimes they're fairly obvious stuff that we need to remind ourselves. Sometimes they're all the what ifs and yeah buts and all of these crazy hypotheticals, but it's good to think through that stuff.
Yeah.
So our first question is from Nikki. Can you please discuss the hairy issue of no-knock warrants and what the next steps would look like if the homeowner defended themselves, being unaware of their intruders' identities? This happened.
Yeah, so no-knock warrants, that's when law enforcement goes and basically without knocking on their door and announcing themselves, they kick in the door, they go inside the house, and then the scenario that has happened quite a few times in the past is somebody hears somebody breaking into their house and they respond to it like it's a home invader. First case I heard about this was, I think about 8 years ago in Massachusetts with a Vietnamese immigrant that didn't speak English, that law enforcement went into his house. They were yelling out police and he had no idea what they were saying and shot back at him as they were going in. Typically, you're going to need to, as soon as you figure out that it is law enforcement, surrender. Once you know that it's cops, don't keep shooting at them. Drop the gun, put your hands up, surrender to them. We're going to handle this in the legal system. And if somebody is broken into your house, you have a reasonable belief that this is an intruder, and you shoot back at them, especially if they've got guns, they don't, they're not marked. You got plainclothes officers coming in. Law enforcement has actually lost a lot of these cases. The civilians that have defended themselves is one. The most clear-cut example of this in recent times was the Breonna Taylor's boyfriend. Ultimately, she got shot during the raid, and that became a huge sticking point there. But remember, her boyfriend ultimately wasn't even charged with shooting at the officers in that. So it's actually a fairly good situation. I mean, not a good situation, but it's a workable, defendable situation. Surrender as soon as you know they're law enforcement, and then lawyer up because you're going to be facing a whole bunch of questions.
That's really good advice. Our next question is from Cade. So what to do if less lethal, like pepper spray or no force is used, and the situation may or may not warrant police? Does FLP help? Well, first of all, from FLP, I'm just going to say we're going to assume you need help. The second you call, you pick up that card and call us, our assumption is you need help, and we're going to scramble everything we can. James?
Yep. I've gotten those calls as well from people in this kind of situation. And even if they're not going to be facing charges, we're not going to be doing anything with them. I'm going to sit down. I'm going to talk to them about here's what the legal process is. Here's where your rights are. Here's what you could possibly be facing. If they come back at you, call me. I'm going to go out there when you get interrogated with this. I've absolutely helped people out in those situations. But what should you do if you don't use deadly force or you use less lethal force? You should call law enforcement. One of the most common ones that I see is somebody feels that they are in imminent danger, so they wind up pulling out and displaying their firearm but not pulling the trigger. And they think that, well, because I never pulled the trigger, I'm not going to be getting in any sort of trouble for this. A lot of states use different terms for it. The brandishing is the one that I hear most often. In Colorado, we call it menacing. Felony menacing is placing somebody else in imminent danger of death or serious bodily injury by use of a deadly weapon. So in that case, if I pulled out my gun, I displayed it, I've just committed a felony, but self-defense applies. So I have to explain why my actions were reasonable. One thing I can tell you is if you display that gun, that person that you have displayed it to, this probably isn't the first time they've ever been in trouble with the law. They've been getting in trouble since they were kids. And one of the things they learned early on is blame the other guy if you get in trouble. And if they think that, crap, they're going to call the police on me and all of a sudden I'm going to be facing a case for what I've done here, they're going to call the police and say, I was delivering a load of cookies to the orphanage and this crazy guy with a Trump and NRA bumper sticker ran me off the road and pointed a gun at my face. And unfortunately, the only physical evidence that's going to be there in that case is going to be that gun. So I would call the police first and let them know, hey, this other guy was threatening me. I felt that I was afraid for my life. And if he doesn't call the police, he doesn't report it, great. It's an unsolved thing, but the presumption is that you're guilty. And if he does call the police first, you called it, you report it, your side of the story is out there. And it makes it easier for me to be able to say, hey, this is what he told the cops on the scene. This is what matches what he's telling you on the stand today. It helps my case out.
Awesome. That's super helpful. We got another question from Ed. You kind of went over this in the presentation, so I think this is just a super quick recap of why do we hang up as soon as we have told 911 that there's been a shooting? If someone's shot, why don't we tell them to also send an ambulance?
Yeah, definitely tell them to send an ambulance, send police. You just don't want to stay on the phone because you don't want to say too much to them that can be kind of twisted against you later. It's all tape recorded.
Yep. Question from Rob. Can I defend my car and myself with deadly force against a carjacker?
So this is one of those questions that kind of varies from state to state. I can tell you with certainty that in Colorado, the answer is no, you can't defend property. And I've been looking up Texas and Michigan because I know there's a lot of Texas and Michigan people as well. And generally, even in those states, you're not allowed to defend property with deadly force. Texas gets a little bit close, but it's not 100% there, especially when we're talking about a car. But in most of the cases when we're talking about carjacking, what are you defending? Are you defending your car? No, you're defending yourself. Because if somebody is carjacking me, that means they're trying to use force to take my keys, to take my car from me. So if I wind up using deadly force, we go back to that same standard. Am I in imminent danger of death or serious bodily injury? And do I have a better way to solve this than using deadly force? If I'm in danger and I don't have a better way than using deadly force, yes, I can use it to defend myself. Unfortunately, with a car, if we're talking about carjacking, the more often better answer is going to be you just hit the gas. And, that may mean you run the guy over, in which case, bonus points there. Or you just pull away and get away from him. Or if he's pointing a gun at your head and you've got to, use a gun from the car window, these are all decisions you're going to make in a split second. And it's my job as your attorney to help take that half a second decision you made of whether or not I'm going to pull my gun and defend myself, or whether I'm going to try to run, or I'm going to try to hit the gas, or I'm going to try to do something else here, and turn that half a second decision into a 15-paragraph essay on why the only reasonable option you had was to use your gun to defend yourself.
Awesome. Question from Brett, and I think this could go into a long discussion, so I think this is just the quick overview version.
Yeah.
But what does the bail and pretrial release process look like?
Again, this is going to be different from state to state. Colorado, we love bounty hunters and bondsmen here. So typically, if a bond is set, if I have $1 million bond on my case, I can either post $1 million to directly pay that to the court, and then at the end of the case, I'm going to get $1 million back if I'm found not guilty, or actually, even if I'm found guilty, when the bond is closed out, I get the money back. Or if I could go find a bondsman and give him usually about 10% of what the total amount is, so $100,000. Then they're going to give me, I'm not going to get anything back at the end of that because that's the fee that I paid to the bondsman. So less money to go to a bondsman, but you don't get anything back, or more money to the court and you get everything back. And FLP does $250,000 for bond, which I think is great because absent, actually, I've even seen some murder cases where lower than $250,000 bond has been set. So that'll cover just about everything for you.
Great. Thank you for that overview. Richard's asking, I want to know more about protecting my family's life, myself, and others when it comes down to an active shooter in a public place. Mm-hmm. What are my legal rights in this situation?
So your legal rights is in regard to an active shooter in a public place are exactly the same as your legal rights any other place. All right. Am I in imminent danger of death or serious bodily injury? And do I have a better option than using deadly force to stop this guy? If I am sitting, in the local Waffle House and some guy walks in with a rifle and starts shooting people sitting in the counter and he's coming towards me, I'm in imminent danger. I'm going to turn around. I'm going to respond because this guy's got a gun. He's shooting people in public. I think he's going to shoot me, and I need to stop him as quickly as possible. If I'm in my church foyer on Sunday and some guy starts shooting in the foyer there, even if I'm on the other side of the foyer and I don't think he's going to come to me, I'm probably going to return fire there because he is randomly shooting people. And the longer he is able to do that, the more people are going to die. So it is going to be completely reasonable for me to take even a long shot to try to drop that guy.
That's awesome. That's super helpful. So whether you're at home, in church, in a public place, you've got the same rights to defend yourself, but also you have no obligation to suddenly become Batman or Superman and swoop in and save everybody there.
Yeah, that's absolutely true. Just because you have a concealed carry permit does not mean that you're a junior sheriff's deputy or something like that. You don't have to respond to crimes. You don't have to stop somebody from doing something. I hear this all the time. If I've got a concealed carry permit and somebody starts shooting in the Walmart that I'm at the back end of, do I have to run over there and do I have to try to stop this guy? And the answer is no, you don't have to. You're never required to. And I hate to tell people this, neither is law enforcement. But as a civilian, you're especially not required to. And I can tell you that if I'm in Walmart and I've got my two girls with me and I hear gunshots at the front of the store, there is no way that I'm going to say, okay, sweetie, stand here behind the cereal. Daddy's going to go try to take on a mass murderer up at the front of the store. I'm going to get them out because they are my number one priority. But if I'm in there myself, I'm not carrying my little pocket 380. I've got a Glock 19 or something like that. I'm feeling pretty good. I have my monster before I walked in there. Yeah, I may decide that I'm going to go up there and I'm going to get into a gunfight with this guy. Or I can decide I'm going to save my life. I'm going to have another day to fight, and I'm going to go out the back door, and I'm just going to save myself.
Awesome. Alan sends in a question. If an incident takes place while traveling through several states, how should this situation be handled? Well, my guess is the actual situation probably happened in one specific state, unless you happen to be in, spanning the Red River or on the Four Corners or something.
Yeah.
I'll let you get into that.
Yeah, so hopefully you're not crossing state lines while it's happening, because that sounds a little bit more like an OJ low speed chase sort of thing going on here. But it needs to be handled exactly the same way from state to state. What I'm giving you is good advice for whatever state you happen to be in. Fifth Amendment applies everywhere. Sixth Amendment applies everywhere. Fourth Amendment applies everywhere. Call police, lawyer up, make sure that you're safe before the cops get there, and then talk to your attorney before you make any statements.
Awesome. Question from Elizabeth here. So my CCW instructor said we are allowed to shoot a home intruder who's leaving the house in Michigan. This is counterintuitive to everything I've ever learned about. Is that true?
I would say no. And granted, this is one of those things where we need a little bit more information. But I looked up the Michigan Castle Doctrine here, and what it says is that you're given the presumption, it's a rebuttable presumption, that you are in fear for your life if somebody is broken into your house. It's essentially the way that works there, but it's a rebuttable presumption. And what that means is that, yes, the jury is to be instructed that because this person broke in here, I'm presumed to be justified if I shoot this person. But the DA's office is still going to say, okay, but wait, he was walking out your back door and you weren't in any sort of danger. That's not going to be a justified shoot. In Colorado, you have to be able to show that even though this person broke into my house, I was in fear they were going to use some level of harm against me. It wasn't necessarily deadly force, but I thought they were going to do something to me. You can't shoot somebody just to protect your own property. And even Texas, which is going to be the most lean in on these sort of things, says that you have to believe that your property or your person can't be protected by any other means than shooting this fleeing person here. So if this person is walking out my back door and they've got my daughter by the hand there and they're dragging her out, am I going to shoot them in the back as they're walking out the door? Absolutely. But if they're just walking out with my TV and about to run out my back door, I can't shoot them to protect my TV, and I'm not going to fire that shot.
Awesome. Thank you for clarifying that. That's an important one. This one's similar to a question we had earlier. But there's one little nuance here. So should I call the police after a non-lethal altercation, and what should be said to 911 and the responding officers? And I think some of that is on our card, but it says there's been a shooting. So if there hasn't been a shooting, what should be said? Yeah.
And this is one of those things that kind of kills me a little bit as an attorney to say, because the answer that I want to give everybody is don't talk to the police until you talk to me. But just from practical experience, I've had too many cases where people have said, I just displayed a gun. I'm not going to call the cops because it worked exactly as I intended. The guy ran away. He realized it was a fight that he didn't want to get into, and I didn't have to display, or I didn't have to pull the trigger at the end of it. And I've just had too many clients that have gotten charged because the other guy calls the cops and says, hey, some crazy guy pointed a gun at me and said he was going to kill me. So my advice is, yes, call the police, give them a short description of what happened. basically say this guy, he was threatening me. He was road raging me 9 out of 10 times. That's what it's going to be. He's trying to run me off the road. I thought he was going to kill me. I held my gun up and said, back off, dude. And he did. And I was in fear for my life. And then kind of leave it at that and say, I want to talk to my attorney before I say anything more. That way I can help you explain a little bit better why you thought what you thought at the time you thought it.
Gotcha. That makes a lot of sense. Well, we've received a whole lot more questions here as we've gone through it. And like I said at the beginning, a lot of these topics, you can take it into a bajillion different directions in terms of, well, if this and this and this and all these specific situations happen. So if you're an FLP member, you can use your mobile app and send us a message if you have specific questions that we didn't answer tonight. If on our next webinar, you want to make sure that your question gets answered, that it floats to the top of the list, we take questions at registration. There's a field where you can put in a question. We give those priority because some of them are going to be the same as what people send in through YouTube. Some of them are going to be different, but we can't sit here all night and answer every single question. So make sure you register for the next event and list your question. So with that, James, do you have any other parting thoughts?
I've just seen this question pop up about 3 times there on the chat about whether or not you should have the number memorized. How does law enforcement treat that?
Okay.
My response to that is if you tell them, hey, I've got a lawyer, I've got the FLP program, the card is in my wallet, and they say, no, we're not going to give you that card. You have to talk to us without your lawyer. I'm going to have an absolute field day in court getting everything you said suppressed and all kinds of evidence thrown out with it. So I wouldn't be too concerned about that. When they get there, ask them for the FLP card. If you haven't memorized, that's great. Or in my case, my wife knows what the card is. She's got the sticker up on the refrigerator. She can call for me if I need to, but just ask for the lawyer.
Yeah, that's awesome. And a lot of our members will save it in their phone as a contact. So you can just say, hey, Siri, call FLP or whatever you need to do.
Yeah.
Well, thank you so much. This has been a great presentation. Like I said, some of us, this is new information and it's so important. It's stuff that could literally change your legal and financial situation for the rest of your life. And some of us, this is just a good refresher. So James, thank you so much for doing this. To everybody who attended tonight, I hope you enjoyed it. Happy Easter. Have a wonderful evening. Until next time, protect yourself and we will protect you.